Molly Cat is absolutely correct. When you contact a bankruptcy attorney and you tell them, these are my assets, this is my household size, this is my income, this is the equity in my home, these are the cars I have, if you made any transfers in the last year, what your bank accounts look like. When you give them all their information, then they're going to tell you, yes, you qualify for Chapter 7 bankruptcy and there's no real red flags that they see, or they're going to say, sorry, you don't qualify for Chapter 7, you just make too much for the means test in your particular state, so therefore your other option is a Chapter 13. They're not just going to go and take your money and file your case without giving you some semblance of assurances, whether you are a Chapter 7 or a Chapter 13. There's no such thing as your bankruptcy getting denied. That's like a 0.1% chance of your bankruptcy getting denied. That's for people who have committed large levels of fraud. If you don't do any of that stuff and your bankruptcy attorney catches any red flags or issues that they see with your case, then you will be fine. In terms of the Chapter 7, they're not going to go and file a Chapter 7 if you make way too much money or you have just too much equity in your home. They're going to tell you, sorry, you have to do a 13. And then you make a decision at that point. So when we get to the 341 hearing, it's pretty smooth sailing at that point if your petition is absolutely correct and all of your information has stayed the same. So don't worry too much about getting denied. Find the right attorney in your state who's willing to give you some really definitive advice. As for me, I'm in California. I practice everywhere in California. That's all of Northern California, all of Southern California, and I actually also just got approved to practice in the Southern District, which is San Diego. Okay, Merry Christmas.